Major breaking news, a huge argument is on Monday. This is the case that is likely to go to the U.S. Supreme Court on the questions of whether or not an AR-15 and or semi-automatic rifles can be banned, in addition to questions about so-called large capacity magazines. That's right, we're going to break down the Barnett argument in the U.S. Court of Appeals for the 7th Circuit, and I'm going to give you the arguments that I would make sure got made if I were doing the argument on Monday in the 7th Circuit. We'll break it down and talk about it when we come right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, we're going to get right down to it now, which is the United States Court of Appeals for the 7th Circuit out of Chicago, Illinois, will be hearing a series of cases referred to basically collectively as the Barnett case, all of which arose out of a major trial in front of that most excellent federal district court judge, the Honorable Stephen McGlynn, in the United States District Court for the Southern District of Illinois, wrote a series of excellent opinions, including a post-trial opinion of finding of fact and memorandum of law, an excellent opinion laying all that out, explaining why Illinois' ban on AR-15 semi-automatic rifles and magazines that hold more than 10 rounds are unconstitutional. Unfortunately, that appeal went to the U.S. Court of Appeals for the 7th Circuit based in Chicago, and that argument for the merits, if you will, previously had been in front of the 7th Circuit on a preliminary injunction. It had been up there on a stay of the lower court judgment and things like this, but now is the big enchilada. Monday is the oral argument on the merits of this case for a final judgment and make a final decision, which means we are a one whistle stop away. This decision by the 7th Circuit, one whistle stop away from this case going to the United States Supreme Court. Now, the three-judge panel is Judge St. Eve, Judge Frank Easterbrook, Judge Michael Brennan. In my view, we're going to lose this case 2-1 because Judge Easterbrook is a total embarrassment and a complete disappointment to the conservative movement and to the constitutionalist and originalist movement, and everyone agrees with me, I suspect, including Frank Easterbrook. When he looks in the mirror, might even agree that he is disappointed with himself. Beyond that, we also have Judge St. Eve, who has demonstrated herself to be no friend of the Second Amendment, has screwed up the Bruin-Heller methodology on multiple cases, so I suspect she'll be bad on this case as well. And then you have Judge Michael Brennan, who's gotten it correctly, a Trump appointee who's gotten the Second Amendment issues correctly over and over and over again, but he's on a terrible panel. And I suspect the Barnett case may very well be the AR-15 semi-automatic rifle ban case that goes to the Supreme Court, where we are ultimately vindicated in support of a right to keep and bear arms. So I just want to go through some of the big arguments, the ones that are kind of nuanced, if you will, that if, for example, if I were Harmeet Dillon, who I'm sure will do a fantastic job on Monday, remember this is the case where the head of the Civil Rights Division at the Department of Justice, Harmeet Dillon, is going to argue some of the argument in support of the Second Amendment. And of course, the lawyers for the private parties will also be arguing in favor of the Second Amendment on Monday against the lawyers for the state of Illinois. So, for example, if I were representing the Department of Justice before the 7th Circuit, what are the handful of arguments that I want to make sure that I was ready for in terms of questions and answers, and to make sure I had it nailed? Here they are for what it's worth. So the first question I want to be ready for is exactly where do arms play a role in the text of the Second Amendment? The text of the Second Amendment reads, "The right of the people to keep and bear arms shall not be infringed." The question is, what is an arm and how do we know that? And do we think suppressors are arms? Do we think that AR-15s are arms? Do we think that magazines that hold more than 10 rounds are arms? How do we analyze this? And the answer is really quite simple. When you look at the plain text of the Second Amendment, you are engaged in a form of linguistic analysis or semantic analysis. You're basically just trying to understand the words as they were written in 1791 when the Second Amendment was adopted. That's why you sometimes see that word that says text as informed by history. The meaning of that is that the text has to be locked into the relevant time period. You cannot take a 21st century definition and somehow apply it to 1791, because you want to understand what the people meant when they adopted the Second Amendment in 1791. So that's where you get that reference to text as informed by history, because you look at the historical time period. And the Supreme Court has already done this work, because in the Heller case, which dealt with the D.C. handgun ban, the Supreme Court already defined what is an arm for the purposes of the text of the Second Amendment. It is anything that can be used offensively or defensively. They use several dictionaries from the time of the founding, both from Noah Webster and Samuel Johnson, among others, to find that anything that can be used offensively or defensively is an arm. So when it comes to firearms, obviously all firearms are arms at the textual level, which means if you regulate an arm, if you regulate a firearm, if you ban a firearm, guess what? The burden shifts to the government under the Heller-Bruen test to show, this is what the government has to prove, they have to establish their burden and prove their burden, which would be that there's some sort of long-standing historical tradition of firearms regulation consistent with modern firearm law. And here, because you're dealing with literally arms bans on AR-15s, bans on magazines that hold more than 10 rounds, the Supreme Court has already articulated the legal standard to apply in these cases, and that is the in common use test. If an arm is in common use by Americans for lawful purposes, it cannot be banned. And critically important, do not screw this up, and critically important, the burden of proof is on the government to show that an arm they are regulating, that an arm they are banning is a dangerous and unusual weapon, which means the government bears the burden to show that the arm they're trying to regulate and or ban is not in common use, because the in common use test arises from what? From the long-standing historical tradition of a firearms regulation consisting of regulating dangerous and unusual weapons. And if a arm is in common use by Americans for lawful purposes, by definition, it cannot be unusual, and thus it cannot be dangerous and unusual, which means the government simply cannot prove, in this case dealing with the most popular rifle in America, the AR-15 semi-automatic rifles, or magazines that are even more ubiquitous than these arms or these firearms, so there's no way for the government to win. But the burden of proof is on the government to show these arms are dangerous and unusual. The burden of proof is also on the government to show they're not in common use, which goes back to my point that really Second Amendment proponents simply have to look out the window and do nothing and win these cases. But that's not what happened here, because in that trial in front of Judge Stephen McGlynn in the Southern District of Illinois, Judge McGlynn found all of these arms to be ubiquitous and obviously protected under the Second Amendment because they're clearly in common use. Everyone understands this. Even the Washington Post survey found that AR-15s are in common use by Americans for lawful purposes. This is not a heavy lift. Now, beyond firearms, we also have to understand that things like suppressors and, for the purposes of this Barnett case, magazines are also arms as a matter of plain text. And why do I say this? There's two easy answers. If the court asks, for example, Harmie Dillon, are these magazines as a matter of plain text protected arms? Are they arms? And the answer is they're clearly arms. Because remember, the U.S. Supreme Court in the Bruen case specifically said expressly so. They literally wrote it in to the Bruen text when they're discussing what is an arm. In addition to pointing out that modern arms are protected arms under the Second Amendment, they point out specifically that any instrument that facilitates armed self-defense is an arm under the plain text of the Second Amendment. Any instrument which is an object that facilitates armed self-defense is an arm as a matter of plain text. And therefore, a magazine obviously is an object, it's an instrument, and it obviously facilitates armed self-defense because it allows you to fire more rounds without having to manually reload. So therefore, under the Bruen definition of what is an arm, any instrument that facilitates armed self-defense, obviously a magazine falls within that, and so does a suppressor as well, by the way. Beyond that, obviously, it is clear that a magazine and a suppressor are both arms for the purposes of the plain text of the Second Amendment, because if you, and this is carefully, we've talked about this on this channel before, this is very important to understand. If the government bans a magazine that holds more than 10 rounds, if the government bans a suppressor, if the government regulates a magazine holds more than 10 rounds or a suppressor, what is it doing? It is banning and or regulating what? The government is banning or regulating an entire category of firearms themselves, specifically firearms that are capable of firing more than 10 rounds without having to be manually reloaded. So if you ban, guess what? Magazines that hold more than 10 rounds, you've banned an entire category of firearms that are capable of firing more than 10 rounds without having to be manually reloaded. It is a categorical ban on an entire category of firearms, which again means the Heller in common use test applies. And of course we know that firearms that hold more than 10 rounds are ubiquitous. They're everywhere. They're clearly in common use. And again, remember, because it's the in common use test, the burden is on the government to show that magazines and guns that fire more than 10 rounds with these magazines are not in common use, which is simply impossible for the government to do, because the fact is they are in common use and everyone understands it, which is exactly why the anti-gunners want to ban these things, because there are too many of them in the minds of the anti-gunners. Now, beyond that, if I were going to do this oral argument, I would be ready for a question that says, but isn't there a problem with the in common use test? It makes no sense. It's circular, all these kinds of nonsensical things. I would have two answers to that question for the court. Number one, it really doesn't matter if the Seventh Circuit panel of 3 judges doesn't like the in common use test. It doesn't matter if they think it's bad. It doesn't matter if they think it's illogical. Why? Because they are what is known under Article 3 of the United States Constitution as inferior courts to the Supreme Court. The Supreme Court set forth, having looked at the text and the history of the Second Amendment, and adopted the in common use test that said if an arm is in common use, it cannot be banned. And they relied in part on the U.S. Supreme Court decision of Miller from the 1930s. So whether or not Judge Frank Easterbrook, who is a genius in his own mind, thinks that the in common use test is good or bad, it does not matter. Because as an inferior court, they are bound by the in common use test. So it really doesn't matter what they like. As an inferior court, they have sworn oath to uphold the Constitution as set down by the U.S. Supreme Court. They must follow it. That's the first point. But number two, it is incorrect to say the in common use test is not accurate as a matter of historical law and doesn't make sense. Because let's pause for a moment. What does the text of the Second Amendment actually say? It says the right of the people. Oh, what was that? The right of the people to keep and bear arms shall not be infringed. We're talking about the right of the people. The right of the people to do what? To choose their own arms. If we, the people, decide as a collective, together, obviously individually through our individual choices, that we all want to have AR-15s for lawful purposes, and we all want to have magazines that hold more than 10 rounds for our handguns, our semi-automatic pistols, and for our rifles. We get to decide, because it is the right of the people to decide about the right to keep and bear arms. It's not up to they, the bureaucrats, or they, the legislators. So the reason why the in common use test makes sense to establish that if we decide overwhelmingly to pick a kind of firearm, a category of firearm and magazines and suppressors and whatnot to own, we, the people, have chosen the arms that we want to own. And it is our right, after all. It literally says so in the text of the Second Amendment, the right of the people. And the people have decided that AR-15s and magazines that hold more than 10 rounds are what we want. And we get to decide because we are the sovereign and they, the government, are not. So again, it doesn't matter what Frank Easterbrook thinks about the test. He's bound by it. He has to apply it, and we win under that. And number two, it's nothing wrong with the test because we, the people, decide what guns we want. And that's exactly what the Heller case said in 2008 when the Supreme Court says, for whatever the reason, handguns are the preferred choice for the purposes of self-defense by the American people, and therefore they cannot be banned. That's not just this handsome YouTuber on the 4 boxes downer. That is the U.S. Supreme Court in 2008 in the Heller decision. Verbatim. That's what they said. And that's binding on Judge Easterbrook and Judge St. Eve. Whether or not they agree, who knows? But again, I think this is one whistle stop away from the Supreme Court. So at the end of the day, it doesn't matter so much what this panel says to Barnett, because it's going to go to the Supreme Court and the anti-gunners are going to lose there. And the last point I'd be ready for arguing this case would be, why does anyone need an AR-15 for self-defense? What's the point? And I would say several things. Number one is long guns, including AR-15s, are far more accurate than handguns. You don't have as bad a recoil. AR-15s are a lot easier for people like women and the elderly and people that are not as strong. to handle, more so than, again, handguns. And because AR-15s are more accurate, you're more likely to hit your intended target, the bad guy, in a self-defense scenario, and you're less likely to cause collateral damage by missing the bad guy and hitting someone behind the bad guy. And again, we the people have chosen these guns. This is why it's the most popular rifle in America, because they're easy to operate, they're reliable. People like to fire AR-15 style firearms, AR style firearms, AK style firearms, and of course, semi-automatic rifles. And the last point, of course, I would simply make, even though you're not supposed to consider this, is just a practical point, that the number of people killed in homicides with handguns, and including in mass shootings, is far greater with handguns than with AR-15s and rifles. We know that. Just statistically speaking, there's only a few hundred people are killed every year with long guns in homicidal situations. And beyond that, you cannot argue that mass shootings are an unprecedented social change or unprecedented societal event or issue or something like that. Because keep in mind that if you look at the language in Bruin, this is very important, if you look at the language in Bruin, it says that in cases other than Heller and other than Bruin, courts may have to consider historical analogs in some sort of more nuanced way if dealing with an unprecedented societal event or something along those lines. But it specifically carves out the dependent phrase. If you look at the dependent clause at the start of the sentence, in cases other than Heller and here in Bruin, in other cases other than Heller and Bruin, you may have to be more nuanced if you're confronting these societal changes or technological changes or whatnot. And we know that mass shootings are not unprecedented as of 2022 in Bruin, because they were not unprecedented in 2008 when the Heller case was decided. Because just alone in 2007, you had the Virginia Tech shooting in addition to Columbine and other issues like Stockton. But you had the 2007 Virginia Tech shooting where somebody used handguns, semi-automatic handguns, and magazines that held more than 10 rounds to engage in a mass shooting at Virginia Tech in 2007. And yet the Supreme Court decided Heller in 2008 with the in common use test and finding out that you cannot ban handguns, including semi-automatic pistols. So you cannot say that mass shootings are unprecedented societal changes allowing for you to ban guns or anything like that, because those existed in 2008 when the Supreme Court set forth the legal standard. So whatever the court is talking about in terms of something that's not precedented, today in 2025, whatever it might mean, it 100% cannot mean mass shootings, because they were known, understood, and literally litigated, because the Virginia Tech case was discussed at the Supreme Court in the Heller case in 2008. So whatever they're talking about today in terms of unprecedented events, it is not mass shootings, because those were discussed in 2008. And by definition, if it was discussed in 2008 as something that was already occurring, it cannot be unprecedented in 2022 for Bruin or 2025 today, because they were well established as unfortunate tragic events of these nutjob murderers engaged in this kind of conduct with modern firearms. And that was well understood that that was a risk in society back in 2008. And the Supreme Court still decided Heller the way they decided it. Okay, folks, so there you have it. Hope you enjoyed today's episode. Make sure you follow me on X at 4Box Diner. Don't forget to subscribe both to YouTube and to Rumble. And I look forward to talking again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.